Welcome to literary and jury charge practice. Let's start out with some practice from this closing argument. Ready? Here we go. A secretary to the sheriff, she deals with lots of people every day. Undoubtedly is in contact with lots of folks, deputies and civilians who are involved in cases where people were shot. She had no particular reason to document this conversation. She wasn't talking to the defendant about any business related to her job. She isn't a law enforcement officer. She wasn't recording the conversation. To Ms. Guerra, there was no reason this conversation should have been particularly memorable, and it wasn't, but that doesn't mean it didn't happen. Shortly thereafter, the defendant repeatedly told Georgina Richardson that he intended to demolish the old barn. This had Ms. Richardson concerned, especially after the defendant called her at 5 a.m. to tell her. So she called sheriff's deputies. But then the autopsy had been done, and the findings prompted Sergeant West to obtain a search warrant, which was served on July 13, 2012. At this time, the detectives and crime scene specialist did a thorough search of the old barn. They took several hours to list and inspect every piece of junk in that building. Eventually, after moving all that stuff, they found a Moon 9mm pistol next to a holster for the firearm. The box for the gun was found in the house July 9th, but the gun wasn't there at the time. There's another shot of another exhibit. Shows the holster and the gun together. The fact that the gun and holster were found next to each other makes it more likely they were intentionally placed there rather than just being thrown away into the junk by a burglar. Also found nearby was a fired cartridge casing, which a firearms identification expert later determined it was fired by the Moon 9mm pistol. That was a stipulation you heard, and that has been conclusively proven. No dispute about that. Also determined that the defendant's DNA was on the firearm. That was stipulation number 3. While at the scene, Georgina Richardson gave sheriff's deputies 3 bags of clothing that the defendant had with him in the car ride from Laguna Beach to San Bernardino. The defendant told Georgina that he just bought new clothes because the sheriff's department wouldn't let him keep his clothes or something like that. On July 10th, Ms. Richardson saw the defendant throw all 3 bags of clothes into a trailer that they use as a trash dumpster. Ms. Richardson, who suspected they were evidence in the death of her mother, retrieved those bags and hid them in the cellar. Ultimately, those bags were tested on February 2015. 3 years later, and gunshot residue was found on a pair of blue Eddie Bauer jeans you see on the left and a plaid jacket. And if you remember, those are the same clothes the defendant wore in that photo you saw him in earlier. That photo was taken July 9th. And it just so happens that he was wearing those clothes as I put on that screen. And it just so happens that he threw those clothes in the trash after the murder on July 10th, the day he had a second interview with sheriff's homicide detectives. Now I'm going to talk a little bit about the law of homicide. Then I'll be done. I'll tell you one thing about learning the law. I didn't always want to be a lawyer. I started out as a newspaper reporter, and I get assigned to cover the court in this community where I work. And I would see lawyers in action, and it was very inspiring to me because I realized, seeing these lawyers in action doing trials, I realized one very important thing. You don't have to be that smart to be a lawyer. You have to go to law school. That takes a lot of time and money, but the legal concepts in and of themselves are not that complicated. That is especially true in this case. Here, there's no issues of heat of passion or self-defense or anything. In this case, the legal issues are very clear. We will start with second-degree murder. All murders are killings of malice. Once you know what malice is as defined by the law, you'll know what a murder is. Right, we will get back to this. Next, we'll try some literary material. Let's see what we have. This is called Traveling with Aging Parents. Ready? Here we go. Valerie Grubb loves to travel. Not only that, she loves to travel with her mom. In the past 20 years, the author of Planes, Canes, and Automobiles, Connecting with Your Aging Parents Through Travel, has logged more than 300,000 miles with her mother, now 85. It's been one of the best things I've ever done, she says. You too can have a great trip with mom or dad, even if they have mobility challenges. Just follow a few of Grubb's tips. Watch them walk. Don't leave home without understanding your parents' physical capabilities. That may actually help you decide where you want to go, says Grubb. A parent who struggles with the porch stairs won't be climbing the 387 steps to the top of Notre Dame Cathedral. If you can, pay your parents a visit and observe them so you can help them make the best choices for the trip. Talk to the doctor. Go with your parent for a pre-trip checkup to discuss health concerns and details about medications, including generic names your parent is taking. Carry a list of those medications and their doctor's contact information with you at all times. It's rare that something happens when you're just at the hotel, Grubb says. Remember that things change. If you haven't spent extended recreational time with your parent in a long while, be aware that their dietary preferences may have changed, their memory may have diminished, or they may need more frequent rest stops. Grubb notes her mother was once fearless, but became more wary of new places and of flying alone as she grew older. With patience and forethought, most issues can be overcome. If changes It changes the vacation a bit, but I can tell you it's worth it, Grubb says. Travel puts you and your parent in a new adventure and allows you to deepen your relationship. Grubb, for instance, learned during one trip that her demure mom had been kicked out of high school for fighting. You're going to find out so much more about your parents when you're with them, she says. New places trigger memories in all of us. Right, now let's get to some jury charge practice. Ready? Here we go. Members of the jury, now that you have heard all of the evidence, it is my duty to instruct you as to the law of the case. A copy of these instructions will be sent with you to the jury room when you deliberate. You must not infer from these instructions or from anything I may say or do as indicating that I have an opinion regarding the evidence or what your verdict should be. It is your duty to find the facts from all the evidence in the case. To those facts you will apply the law as I give it to you. You must follow the law as I give it to you, whether you agree with it or not, and you must not be influenced by any personal likes or dislikes, opinions, prejudices, or sympathy. That means that you must decide the case solely on the evidence before you. You will recall that you took an oath to do so. In following my instructions, you must follow all of them and not single out some and ignore others. They are all important. To help you follow the evidence, I will give you a brief summary of the positions of the parties. I will refer to Nona Marvisa Gay, Frankie Christian Gay, and Marvin Gay III as the gay parties. I will refer to Pharrell Williams, Robin Thicke, Clifford Harris Jr., professionally known as T.I., Paula Maxine Patton, Interscope Records, Geffen Records, Universal Music Distribution, UMG Recordings, Inc., Star Trek Entertainment, and More Water from Nazareth Publishing, Inc. as the Thicke parties. The gay parties claim that the Thicke parties infringed the gay parties' copyrights in 2 Marvin Gaye musical compositions. For their first claim, the gay parties claim that the song Blurred Lines, written and performed by Pharrell Williams, Robin Thicke, and Clifford Harris Jr., infringes the gay parties' copyright in the Marvin Gaye composition Got to Give It Up. The gays have sued Williams, Thicke, Harris, Interscope Records, Universal Music Distribution, UMG Recordings, Inc., Star Trek Entertainment, and More Water from Nazareth Publishing, Inc. on the first claim for copyright infringement. For their second claim, the gay parties claim that the song Love After War, written by Robin Thicke and Paula Patton and performed by Robin Thicke, infringes the gay party's copyright in the Marvin Gaye composition After the Dance. The gays have sued Thicke, Hatton, Geffen Records, Universal Music Distribution, UMG Recordings Inc., and Star Trek Entertainment on the second claim for copyright infringement. The gay parties have the burden of proving each of these claims. The thick parties deny the gay parties' claims. When a party has the burden of proof on any claim by a preponderance of the evidence, it means you must be persuaded by the evidence that the claim is more probably true than not true. You should base your decision on all of the evidence, regardless of which party presented it. You should decide the case as to each party separately. Unless otherwise stated, the instructions apply to all parties. The evidence you are to consider in deciding what the facts are consists of 1. The sworn testimony of any witness, 2. The exhibits which are received into evidence, and 3. Any facts to which the lawyers have agreed. In reaching your verdict, you may consider only the testimony and exhibits received into evidence. Certain things are not evidence, and you may not consider them in deciding what the facts are. I will list them for you. 1. Arguments and statements by lawyers are not evidence. The lawyers are not witnesses. What they have said in their opening statements will say in their closing arguments and at other times is intended to help you interpret the evidence, but it is not evidence. In the facts, as you remember them, differ from the way the lawyers have stated them. Your memory of them controls. 2. Questions and objections by lawyers are not evidence. Attorneys have a duty to their clients to object when they believe a question is improper under the rules of evidence. You should not be influenced by the objection or by the court's ruling on it. 3. Testimony that has been excluded or stricken, or that you have been instructed to disregard, is not evidence and must not be considered. In addition, sometimes testimony and exhibits are received only for a limited purpose. When I have given a limiting instruction, you must follow it. 4. Anything you may have seen or heard when the court was not in session is not evidence. You are to decide the case solely on the evidence received at the trial. Now let's try some more literary practice. Excuse me. All right, this is called turning points. Ready? Here we go. Weary drivers coasting along Interstate 10 perk up at the sight of the thousands of windmills dotting the hills and valleys in Palm Springs, San Gorgonio Pass. While they might appear whimsical, these hardworking steel and fiberglass soldiers generate electricity that helps power Palm Springs and the rest of the Coachella Valley. Scottish electrical engineer and Professor James Blythe first harnessed electricity from wind power in 1887, and in the 1930s and 40s, this renewable energy source gained favor in rural farmlands. Nuclear power grew popular after World War II, and it wasn't until the fuel shortage in the 70s that power companies were tasked with finding new energy sources. We've been here since the rebirth of wind energy in 1979, says Randy Buckmaster, a guide with Palm Springs Windmill Tours. During the 90-minute tour of the San Gorgonio Pass wind farm, the oldest in the U.S., Buckmaster recounts the history of wind technology, which ranges from old school versions with lattice-style towers to newer models with sleek 3-inch blades. And the number one question people ask: why are some windmills operating and others aren't? Reasons are: it's simply not breezy enough. Wind speed must be 8 to 10 miles per hour before they start turning, or it's too gusty. The windmills cut off at a maximum speed of 55 to 69 miles per hour. All right, that will conclude our literary and jury charge practice.